Before the court today is the case entitled State of Vermont against Eric Champagne, case number 24AP060. Representing the appellant State of Vermont is attorney Andrew Gilbertson. Counsel for appellee Eric Champagne has not appeared.
Okay, thank you very much, and good morning, everybody. Again, counsel, attorney Gilbertson, please go ahead.
Thank you, Your Honors. Good morning. My name is Andrew Gilbertson. I represent the state of Vermont. Your Honors, the state asks that this court reverse and remand the trial court's decision that detention due to defendant's inability to comply with conditions 4 and 11 is unconstitutional and beyond the court's statutory authority. As argued in our memo, this court should reverse because the trial court's erroneous interpretation of the Vermont Constitution and the relevant statutes. First, the trial courts erroneously applied Section 40 to defendant's situation. Section 40 deals with when the court can hold a defendant without bail, but defendant here was held due to his inability to satisfy conditions of release. Second, analogizing detention for inability to satisfy conditions of release as a hold without bail would render parts of 7554 and 7556 superfluous and muddy the difference between 7553A and B, as this court has pointed out before.
So, Mr. Gilbertson, where's the error? I'm sorry, I don't have my video on, but I'm trying to find what the error is that the trial court did when he's obligated to put on conditions of release or cash once the 60 days are over, and he does that. And maybe it's impossible to do condition 4 based on the testimony. So wouldn't cash be the appropriate remedy at that point, or appropriate method of including assurance of the appears?
I think the error is in applying Section 40 to defendant's situation. I apologize if I'm not understanding Your Honor's question quite right.
No, that's that. I was just trying to see where the court went off and made a mistake in his analysis of the imposing conditions in cash.
It was not the state is not contesting or challenging the court's determination of risk of flight and cash bail. The court is, or the state is contesting the trial court's determination that its authority to detain the defendant beyond 60 days because of the defendant's inability to satisfy conditions 4 and 11 was unconstitutional. Specifically, the court found that continued detention violated Section 40. And as we argued, Section 40 does not apply to the defendant's condition. The defendant's situation. The defendant was not held without bail. The defendant was held because of his inability to satisfy conditions of release.
Attorney Gilbertson, just to be clear, it was my understanding that when conditions 4 and 11 were initially imposed, that was not to address a risk of flight. That was solely to protect the public. Is that
yes,
correct?
That is my understanding, yes.
Okay. Thank you.
So how does this amount to not being held for purposes of public protection?
I'm sorry. The current
4 and 11 were imposed for protection of the public. He can't meet those. Why isn't this a hold without for public protection purposes only?
Well, I don't think it's a hold without bail because that is specific for the Constitution, the statute. He is being held because he cannot satisfy those conditions of release, which are related to public safety. So I would agree with the court that yes, that he is being held because of public safety. Specifically, he cannot meet these conditions that the court had previously found were among the least restrictive that will reasonably ensure protection of the public.
So this is preventive detention, correct?
At this point, yes, and unless he can satisfy those conditions, which the court had found were the least restrictive, then yes, it is a preventative detention.
If you can't satisfy condition number 4 by not having an appropriate person, isn't that basically a hold without bail?
No, Your Honor, because he could satisfy that condition at any time. The court has found that up to the point of the hearing, he hadn't satisfied that condition. But a hold without bail is very specific. The legislature created, and the people of Vermont created the hold without bail in Section 40 to address a very specific period of time. That's 60 days after the hold without bail is imposed. And in that situation, there is no possibility of a defendant being released if he is held without bail, even if there's an available responsible adult. But if there is a responsible adult and the trial court finds that that a responsible adult condition can reasonably ensure protection of the public, then that defendant would not be eligible for a hold without bail, because then there would be a condition that will reasonably ensure the protection of the public.
But if, for example, if the person is a 60-day case and the 60-day comes up and the court needs to impose cash and conditions, and the judge says $1 million, which can't be achieved. I mean, isn't that basically a hold without bail, just continuing with the on the 7445A hold, where it's not possible to achieve the bail?
I would agree that the same analysis would apply to the situation where it's impossible for a defendant to satisfy bail, as impossible or unlikely for him to satisfy conditions of release. But we'd argue that's not a hold without bail. Hold without bail is specific for that period between arraignment or the imposition of the hold without bail and those 60 days.
So it's your position that Chapter 2, Section 40 is irrelevant to Mr. Champagne's current status?
Yes.
Okay. And I just want to be clear, there's two conditions in question, Condition 4 and Condition 11, and separate and apart from whether the defendant could meet the Condition 4 requirement, there was also a requirement of a 24-hour curfew, correct?
Correct.
And Mr. Champagne was homeless at the time that condition was imposed?
I'm not sure. I believe the court's prior finding was that he was previously residing at a hotel in the area.
Okay. All right.
Anything else, Mr. Gilbertson?
No, Your Honors, unless the court has any other questions, we respectfully request the court reverse and remand for further proceedings.
Okay. All right, then please call a conclusion of the hearing.